Good evening, everyone. This is the legal issue presentation for Cohort 3, Ms. Hartman, Ms. Keller, and Mr. Mitchell. We will be reviewing the Endrew versus Douglas County School District, case number 15-827, argued January 11th, 2017, and decided March 22nd, 2017. The district situation. The district is receiving increased parent complaints about IEPs, specifically concerning over inadequate student progress, repeated goals, and lack of individualized planning. The parents feel that their concerns aren't being heard during IEP meetings, and many believe goals are too general and not aligned with the children's unique needs. In response, the district is revisiting the Endrew versus Douglas County case to develop a presentation and a proactive plan. This includes district-wide training with a focus on helping special education teachers write meaningful, ambitious goals and the use of data-driven progress monitoring to better support student growth. Now, as we refer back to the Endrew versus Douglas County case, it clarifies that the standards under IDEA for determining whether a student has received a FAPE. It emphasizes the importance of the IEP and the requirement that schools provide students with disabilities with an education that is reasonably calculated to enable them to make appropriate progress and to meet their unique needs. Now, let's review some background information about Endrew versus Douglas. First, Endrew was a fifth grade student that was diagnosed with autism. His parents enrolled him into a private school, the Firefly Autism House, because they believed the education at the public school was inadequate and that it was not allowing him to make enough progress towards catching up with his peers. His parents sued the public school district for reimbursement of the private school. And the reason they did this is because IDEA says that if a free public school cannot meet the educational needs of a disabled student, the student's parents may enroll their child in a private school and seek reimbursement for tuition and related expenses. So because of this disagreement between the district and the parents decided to file a lawsuit and have it heard before the administrative law judge. In 2012, the case was heard, and the judge filed in favor of the district, saying that the district did provide a FAPE for the student. The parents disagreed and therefore took their case through appeal process to the next level court, which was the district court. The case was heard in 2014, and the district court also agreed with the lower court's findings, saying that a FAPE was being provided and the family did not have enough evidence to prove that it was not. So the parents appealed again, taking the case to the U.S. Court of Appeals with the 10th Circuit. In 2015, the courts did favor once again with the district and the lower court's decisions, saying that the minimal standards required under IDEA had been provided and met. So therefore, the family did decide to take this case to the Supreme Court. The Supreme Court did decide to hear the case, and it was petitioned in 2016 for them to review. In March of 2017, the Supreme Court reviewed it and also unanimously voted 8-0 in a decision that favored the family. So the family was granted tuition reimbursement for their private school, and it was ruled in their favor that the district did not provide a FAPE for the student, and it was determined that there was not enough adequate progress as far as the IEP was concerned. Now, as we begin to wrap up the review of the case itself, we want to go over some final outcomes from Endrew versus Douglas. First, the U.S. District Court for the District of Colorado in 2018 stated that Endrew's IEP was not appropriately ambitious because it did not give Endrew the chance to meet challenging objectives. And finally, after 7 years of litigation, the Douglas County School District paid $1.3 million from the district's general fund to settle this case.
When studying the Endrew case, there are many key legal issues that would come up for the district. Number one would be, what is the standard for FAPE under IDEA? And after this case, the Supreme Court ruling that the minimum standard is no longer acceptable. So an IEP must be reasonably calculated to enable a child to make progress based on their unique circumstances. And the IEP must be ambitious for the individual on their present levels and needs for them to make progress. The number two question and key legal issue would be what constitutes meaningful progress towards IEP goals? So, minimum progress is no longer acceptable. The student must have the opportunity to make meaningful and measurable progress toward IEP goals. The student's goals must be ambitious. Here are a few more key legal issues that the district and schools need to be aware of. So number 3, when parents believe that the public school failed to provide FAPE and they end up placing their child in private school, what circumstances are they entitled to tuition reimbursement? So, if a school fails to provide FAPE and the parents do go the route of private school, the school or the district may be required to reimburse. The private school will have to make sure that they're meeting the child's needs appropriately to consider reimbursement. Ways that a school could get in trouble with not providing FAPE could include using the same goals year after year, not monitoring or changing if a student is not making progress, or if the school uses a one size fits all program and does not really adjust for the individual needs. Also, if goals are not ambitious and are not updated once a student masters them, the school could also be found to not be providing FAPE for that student. Number 4, how individualized must the education plan or IEP be? The IEP must be completely individualized for each student. The IEP team must come together to consider the student's strengths and weaknesses, their current levels, and specific needs based off the present levels. The IEP team is tasked with making goals that are attainable for the student and help progress him through the IEP and through the year. The student's progress must be measured through the IEP progress with progress reports. So, after studying the district situation and the district complaint and going through the Endrew case, here's a proactive plan to address the legal issues. So, to require professional development with the whole faculty on understanding IEPs, and then the faculty would receive guidance on what is expected of them in the IEP meeting and what they should bring to the meeting to be prepared. Also, monthly meetings with the special ed team and district special services department to provide updates and guidance on IEPs and writing effective present levels, accommodations, and goals. The team will work with the district to implement standards-based goals on IEPs for students that can be progress monitored with fidelity. DBI, so data-based individualization meetings monthly with the school-based special education team so they can review progress monitoring data, look at interventions and strategies, and document any changes that need to be made. And then also stress the importance of maintaining and keeping clear evidence of parent involvement in decision making and consistent provision of services. Require faculty and staff to keep a documentation log and reference back if needed. Continuing with the plan to address the legal issues, we would check the progress monitoring database currently. So, for our district, that is Easy CBM, to ensure that special education teachers are consistently conducting progress monitoring and entering those scores in a timely manner. And then also making changes if a student is flatlining or declining in their progress monitoring and to change up interventions. And then also, as a principal, it's important to ensure that special education teachers and general education teachers are collaborating frequently and effectively regarding students on their caseloads who have IEPs. So, this includes providing adequate time for them to plan and meet together, strategies for success, and how the special education teacher can offer appropriate support. The principal will check in regularly with staff and help design sufficient planning time to ensure that resource students receive the support they need. The principal will also schedule classroom walkthroughs to ensure that teachers and staff are present and delivering the necessary services, and they will provide meaningful feedback that highlights what teachers are doing well and what they can improve on. In IEP meetings, the principal or assistant principal is typically the LEA. So, as that principal responsibility to be an LEA, that they will ensure that the least restrictive environment is always discussed in meetings and it is appropriate for that student.
The timeline of case law, statutes, and regulations that led to Andrew F. versus Douglas County. So, first, there was a court case in 1982, the Hendrick Hudson Central School District versus Raleigh. At that time, the schools didn't have to maximize a child's potential, just ensure that the child receives some educational benefit and meaningful access to education. The court didn't define how much benefit that meant, but it did say that the districts have to provide progress, like a minimal progress. This case established the FAPE law had to be reasonable and individualized to the student and have some benefit. Then the Urban versus Jefferson County School District. The school district meets its obligation under the IDEA if it provides an educational benefit that is more than D minus. The MM versus the School District of Greenville County. This case in the lower courts often interpreted the previous cases to mean that only minimal progress was required under IDEA. All right. The Andrew case was super important because it said that it had to provide an educational act that was more than just minimum progress and D minus. It has to show that schools are actually making an attempt moved for schools to make progress for the child, and that the goals are individualized and that they are meeting their goals in their IEP. When determining a plan as an administrator, I have to think of the following regulations. The Individuals with Disabilities Education Act, Regulation 34. I need to make sure that the IEP content is correct and that it will be complete for the school that will show adequate progress. Not just adequate progress, but actual accommodations that will help the student meet their goals and help overcome their disability. I also have to make sure to look at the statutes. IDEA 1414 goals have to be meaningful and individualized. They have to be specific for the child. I then have to look at IDEA 1412. Services in IEP have to be delivered with fidelity. Hence why part of our plan included walkthroughs and regular meetings scheduled to see if students are really working towards these goals and the accommodations are appropriate. I also need to make sure that I'm following IDEA 1412A5, where it's the least restrictive environment placement for students. So when a student is given an IEP and we're making sure they are making progress toward their goals and it's maximum progress, according to the Andrew case, that it's appropriate, they need to be in the least restrictive environment. And then IDEA 1412A14. As we put in our plan, there needs to be PD training for staff and faculty in order to help maximize and use IEPs to the best of their ability so students are reaching their goals and showing growth. Final thoughts. From the Andrew F. case, it is important to understand that a student offered an education program providing merely more than D minus progress from year to year can hardly be said to have been offered an education at all. Meaning, we really have to show that we're individualizing instruction and putting in the proper supports for students to make their academic goals. All right. And then also, the IEP must aim to enable the child to make progress after all. The essential function of an IEP is set out a plan for pursuing academic and functional advancement. That shows that they are overcoming their disability and able to succeed in a regular classroom environment, especially a least restrictive environment. Thank you for learning about our presentation. This was done by Lisa Hartman, Suzanne Keller, and Anthony Mitchell.